The deed to a piece of land may come with restrictions or with affirmative obligations. For example, a deed might prohibit non-residential uses, such as building a gas station or opening a doctor's office. A deed may require the property owner to pay annual dues to a homeowners association to maintain a park or common areas. These use restrictions and obligations are attached to property ownership with a legal device called a covenant or an equitable servitude. These restrictions and requirements are written into a deed or a lease, a document transferring rights to property. Covenants are not just contracts between two parties. A covenant or servitude in one deed may then bind later owners of the property, even if their deeds do not mention the restriction. A lawyer representing a home buyer might discover a restrictive covenant in a title report that summarizes information in previous deeds to the property. If the restrictive covenant legally prevents the lawyer's client from using the property as she wishes, she will want to know if the covenant really binds her, and if so, whether the covenant can be terminated and what the consequences of violating the covenant will be. In our study of covenants and servitudes, we will begin with how covenants are created and the rules governing when covenants and servitudes will bind later owners of the land. In our next class, we will move on to how covenants and servitudes are interpreted and enforced, how to defend against covenants and servitudes, and how covenants and servitudes terminate and can be removed from a property title. Covenants are private agreements, usually between neighboring property owners, just like easements. But unlike easements, covenants do not grant a non-owner of land a right to use the land. Instead, covenants impose restrictions and obligations on how the owner of a property can use her own land. In the past, courts sometimes referred to covenants as negative easements, but that term is no longer used. Covenants should not be confused with public land use restrictions such as zoning, tax, and environmental laws. Public land use restrictions are set by statute or regulation. Covenants are restrictions or requirements created by private parties in a lease or a deed. Covenants were created as a kind of an extension of contract law. Landowners wish to have enforceable agreements with their neighbors to preserve neighborhood character and prevent the kind of conflicting land uses we discussed when we covered nuisance law. Suppose that a landowner wants to sell some of the land near her house, but does not want the new neighbors to build any building more than 3 stories high to preserve the view and character of the neighborhood. The owner could obtain a promise from the buyer in the contract of sale not to build more than 3 stories. The problem is this: what happens when the buyer who agreed to the restriction a few years later decides to sell to someone else and move? The new buyer is not a party to the original contract. The law of covenants makes the first buyer's promise binding on all later owners of the property if certain conditions are met. We will then say that the burden of the covenant or servitude runs with the land. A real covenant has to have 2 parties. Both parties have to own land. In order for a deed restriction to work, there needs to be a property owner whose use is regulated by the restriction and a benefited party who could enforce the restriction. We refer to these as the burdened estate and the benefited estate. The word estate just refers to a parcel of real property. If you don't own land, generally you can't enforce a restrictive covenant against a landowner, with some limited exceptions. One of the ways that a covenant can terminate is when the same person becomes the owner of both the burdened and the benefited estate. The covenant is then said to terminate by merger. It would make no sense for an owner to sue herself for violating a deed restriction. There are 2 sets of rules for covenants and equitable servitudes and 2 different remedies for violations because of the historical division between law courts and equity courts in England. If a law court found a valid restrictive covenant in a deed, it would award money damages. More recently, law courts will also grant injunctions to enforce the covenant. If an equity court found a valid equitable servitude in a deed, it could only award an injunction, ordering the present owner to comply with the deed restrictions. We'll begin with the rules for covenants at law, and then I will point out the differences with equitable servitudes. Keep in mind that a deed restriction or obligation might be a valid covenant or a valid equitable servitude, or it could be both. The language of the deed might include the words covenant or servitude, but the labels used don't matter. The lawyers and the court will determine whether the restriction is a covenant, a servitude, or perhaps an easement or some other type of deed restriction. If a covenant meets the elements required by law, the consequence is that it runs with the land. In other words, later property owners are bound by the covenant and later owners can enforce it. To run with the land, a covenant must be created in a writing. The original parties must have been in horizontal privity with each other, and the current owners must be in vertical privity with the original parties. The covenant must express a clear intent that it will benefit and burden later owners of the property. Finally, the covenant must touch and concern the land of both the burdened and benefited properties. More about each of these elements in a minute. The elements for an equitable servitude to run with the land are similar. You will notice that instead of horizontal privity between the original parties and vertical privity with later owners, equitable servitudes are enforceable so long as the later owners have actual or constructive notice of the restriction. A covenant must normally be contained in a lease or a deed, the document that transfers temporary or permanent ownership of land. That means that the grantor of the land is conditioning the grant on the grantee honoring the restriction. It means that the grantor intends to stick around to enforce the restriction. It is easy to see how this works with a lease, because the landlord wants the property back at the end of the lease and wants the tenant to keep certain promises relating to the land. A covenant in a deed usually makes sense only if the grantor has some interest in other nearby land, the benefited estate. Developers of subdivisions will often do this when they grant deeds to different houses in the subdivision. If the two original parties to the covenant are a lessor and lessee, or grantor and grantee of a deed, we say they are in horizontal privity. In contrast, if two neighbors who already own their land make a contract promising each other not to use their property in certain ways, they are not in horizontal privity for purposes of the law of covenants. They have a contract, but it will not run with the land as a covenant, although it might bind later owners as an equitable servitude, as we'll see in a minute. Let's go back to the example of the subdivision developer. If the developer puts a restriction in a deed before selling a home, and the developer still owns other neighboring lots, the developer's retained land will be the benefited estate, and the home being sold will be burdened by the covenant restriction. If the developer then sells a benefited estate, such as the house next door, the buyer of the house next door will want to benefit from the restriction and enforce it. If the benefited homeowner can trace her title through a chain of transfers back to the original benefited grantor, we say she is in vertical privity with the benefited estate. Likewise, later buyers of the burdened lot, that is, the lot subject to the restriction, who trace their title back to the first buyer, are said to be in vertical privity with the burdened estate. The traditional common law rule for covenants at law required both horizontal and vertical privity as one condition for benefited home buyer number 2 to enforce the restriction against burdened lot buyer number 3. In other words, for the restriction to run with the land. You should see by now that restrictive covenants have some things in common with contracts. There was an exchange of promises between two parties, and the courts will grant a remedy if the promises are not kept. The ability of later owners, like home buyer number 2 and lot buyer number 3 in the diagram, to sue and be sued based on the original deal is what distinguishes a covenant that runs with the land from an ordinary contract. In some situations, deed restrictions may be enforceable by parties who are not in privity with the original covenanting parties. One common exception allowed by courts is for promises intended to be enforced by a homeowner or condominium association on behalf of a group of neighbors. The association itself may not own any parcels of land. The association is not in privity with the burdened estates, or in some cases, even with the original benefited estate. A deed restriction might include a promise that the landowner and later owners must pay dues to the association, or that the association must approve significant changes to the building. Courts have come around to the view that the homeowner or condo association is enough like the neighboring property owners that it should be allowed to enforce covenants on their behalf. It would be awkward to have individual owners suing others who failed to pay their association dues. Some deed restrictions are intended to preserve the environment or historically significant buildings. While government also uses public land use restrictions to achieve these goals, the law recognizes the usefulness of private deed restrictions that run in favor of land trusts or historic preservation associations, and allows them to be enforced without privity. A similar motivation allows enforcement by appropriate nonprofits of limited equity ownership restrictions to protect low and moderate income housing. Finally, the equitable doctrine of equitable servitudes moved away from requiring privity and replaced it with the element of notice. So long as later owners have noticed that they are bound by a deed restriction, equity courts dispensed with the need for proving horizontal and vertical privity. The third restatement of property abolishes the distinction between covenants at law and servitudes in equity and calls them all servitudes. A state that follows the restatement will no longer require any type of privity as a condition for a deed restriction to run with the land. Now that we see how the vertical and horizontal privity elements work, let's go back to the other elements for restrictions to run with the land. For home buyer number 2 to enforce a restriction against lot buyer number 3 as a covenant, there are 3 basic elements required in addition to privity. Like any contract involving rights in land, a covenant or servitude must be in writing. The original covenant must reflect an intent to bind later landowners, not just the original parties. So, for example, if the promise in the land sale documents clearly refers to a promise meant to be between the original parties only, it does not run with the land. Finally, the benefit and the burden of the promises in the covenant must touch and concern the land. A bit more about this in a minute. The basic idea is fairly straightforward. A reference, for example, in a deed to a loan of money between a grantor and a grantee would not normally be considered to touch and concern the land, while a promise never to build anything other than a house on the land clearly does touch and concern the land. If the benefited landowner wants to rely on the rules for equitable servitudes, the elements of the rule for running with the land are mostly the same, but privity is not required. So, if 2 neighbors already own land and make a written contract, each agreeing never to build a non-residential structure, and then a later owner who knows about this contract violates the restriction, it might be enforceable against the later owner as an equitable servitude. The later owner still has to have notice of a written use restriction. There must still be intent to bind later property owners, and the restriction has to benefit the other property. The equitable servitude may be enforced by an injunction, but normally a court will not award money damages in equity. The Restatement of Property Third advocates a simpler approach. Under the restatement rules, all covenants and servitudes are just called servitudes. The benefits and burdens will run with the land if you have the elements of a writing, intent to run with the land, and notice to later owners. The restatement replaces the touch and concern test with a reasonableness or public policy test, so that courts have latitude to decide which use restrictions should be enforced by and against later owners. The touch and concern element applies to both the benefited property and the burdened property. So, for example, if Adam agrees in a covenant with Eve that he will not sell alcohol on his property, the burden clearly touches and concerns the use of Adam's land, but the benefit to Eve is unrelated to her land, so the covenant would fail to meet the touch and concern element. The idea behind this element is that later property owners should not be enforcing or being bound by promises that are unrelated to their property. The notice element applies to both parties. It seems fairly obvious that the benefited party, the one who wants to enforce a deed restriction, will have to have actual notice. After all, why would they sue to enforce a deed restriction unless they know about it? The notice issue in most cases is about notice to the burdened landowner, the party whose use is restricted. There are 3 types of notice: actual, constructive, and inquiry notice. Actual notice is straightforward. The property owner knows about the deed restriction, perhaps because it was brought to her attention in a title report, a discussion with a realtor, or in some other document. Constructive notice means that the restriction appears in a deed or another document that is recorded in the county property records and that a diligent title searcher would read, even if the later owner hasn't actually read the deed. Generally, a property owner is charged with knowledge of restrictions that appear in the chain of title leading to that owner. We will study chain of title and recording acts later in the semester. For now, understand that even if a buyer does not actually know about the deed restriction, she is charged with knowledge about restrictions in her recorded chain of title. Inquiry notice means that facts about the property should make it obvious that it is subject to private use restrictions. For example, a house in a subdivision that has shared amenities, such as a swimming pool, is likely to have restrictions requiring payment of dues or preventing construction of non-residential buildings. We will study some cases in detail that will illustrate the concept of an implied negative servitude that would put a buyer on notice even of a deed restriction that is not in the buyer's chain of title. In practice, this means that a lawyer representing a home buyer has to do a variety of fact investigation to be sure his or her client is aware of all the restrictions that will govern their land use. So those are the elements required for a deed restriction to run with the land as a covenant of law or an equitable servitude. In other words, for later owners to be able to enforce or to be bound by promises made in earlier deeds or leases affecting the property.